Blog Talk Radio.
Hello, everyone in the franchise world. My name is Paul Segreto, and this is Franchise Today. Today starts our fourth annual Franchise Legal Series, and what an unbelievable lineup we have in store for you. Today, my guest is Michael Laidhold from Plave Koch. Next week, we'll have Lee Plave, also from Plave Koch. Then on April 25th, Amy Cheng from Cheng Cohen. May 2nd, Barry Heller from DLA Piper, followed on May 9th by Mark Kirsch from Gray Plant Moody, followed on May 16th by Lane Fisher of Fisher Zucker. May 23rd, my guest is Jonathan Redgrave from Redgrave LLP, and then wrapping up the fourth annual series on May 30th will be our IFA Legal Symposium recap, and Dean Heil, staff attorney at the IFA, will be our guest. First time the IFA will have one of their own in our legal series. So really a great time at Franchise Today. Also, some exciting news, too. As everybody knows, Fishman Public Relations is our strategic marketing and PR partner at Franchise Today. We love all that they do. Last night I was informed by Steve Olson, president of the Franchise Update Media Group. They are now also our strategic partner. They'll be our strategic partner for news. So every week we'll have some news sponsored by Franchise Update Media Group. Really exciting time. Just to give a quick rundown of how exciting it is in franchising, just with all the events going on. This month in April, we have the Franchise Finance Conference by Franchise Times in Las Vegas. So you franchise pros, I know you might even be getting tired of running back and forth to Vegas. Seems like everything is out there of late. But then it does shift gears in May. FranCamp, the IFA's new technology and marketing conference, will be in Atlanta, and I'll be speaking at that event. I'm really looking forward to that. And then in June, there's a Franchise Consumer Marketing Conference by the Franchise Update Group, and that will also be in Atlanta. And please understand, those are two different conferences. Don't think going to one kind of gives you the luxury of being able to miss the other one. I would recommend going to both of them. They really are shared from a different perspective. And then, of course, the IFE, the International Franchise Expo in New York, is in June. Really an exciting time for franchising as well as for Franchise Today. You know, thinking ahead to June, as we end our 8-part legal series, and God, we haven't even started it, I'm already talking about ending it. On June 6th, we'll begin a 4-part series, which we'll refer to as the franchise model. And we looked at the various aspects of franchising and divided it into 4 key components. The first one on June 6th will be consumer marketing. June 13th, the segment will be on operations and franchise relations. On June 20th will be franchise sales and development. And then June 27th will be technology and franchising. Didn't think I had to add legal into that mix because we'll be coming out of an 8-part legal series. Then in July and August, we're really putting together a very special lineup for our Franchisor Spotlight series. And this will not be a promotional series. It'll be entirely best practices that some of the leading franchisors have utilized in order to achieve the level of success that they've achieved today. And then, of course, as we get into September, we'll be focusing the month of September on public affairs and government affairs. I'll be working closely with the IFA on that series, and that'll be in conjunction with the IFA's Public Affairs Conference in Washington, D.C. And then October and November, we'll kind of shift gears some. We'll be talking a lot about franchise sales and development. That'll be centered around the West Coast Franchise Expo in Anaheim, as well as the Franchise Update Group's annual leadership conference in Atlanta. And then December, we'll recap the year. We'll have some special events throughout the year as well. We're anticipating another 6 to 10 events throughout the year. So really an exciting time for Franchise Today. Really excited to bring on Franchise Update Media Group as a strategic partner, go along with Fishman Public Relations. Really an exciting time at Franchise Today, and I can't emphasize the word exciting enough, especially as I announce today's guest. And the reason I say exciting because I love the people at Plave Koch. I love the whole, it's a law office, it's a law firm with zing, and really if you go to their offices in Virginia outside of Washington, D.C. and Reston, Virginia, you really feel that type of energy. And I'm really excited that Michael Laidhold, a partner at Plave Koch, is my guest today. But I think I first need to explain that Warren Lee Lewis of Ackerman Centerfeet was originally scheduled to lead off our legal series this year. It was in his fourth year in doing so, or being on the legal series, and he had a family emergency that prevented him from being here, and it was a last-minute cancellation, and our well wishes go out to Warren and his family in a dire time. So please extend your well wishes to Warren as well. But, being able to turn to the folks at Plave Koch and explaining my dilemma and needing somebody at a moment's notice, they were quick to the task. And Lee Plave introduced me to, or actually I already knew Michael Laidhold because he works with one of our partners over at Franchise Foundry. But he was available, minimal preparation time. I really appreciate it. So without further ado, I'd like to introduce Michael. He's a partner at Plave Koch in Reston, Virginia. He focuses his practice on domestic and international franchising, licensing, general dealership, and distribution matters. He works with clients to structure new franchise programs and restructure existing franchise programs, to draft and negotiate franchise, master franchise, licensing, development, and distribution agreements, and asset purchase agreements and related commercial contracts. He counsels clients on compliance with state, federal, and international regulatory issues and provides advice with respect to franchise license and dealership and distribution relationships. He has been a speaker at the ABA Forum on Franchising and the IFA Legal Symposium and other industry events and seminars. Has authored many articles on branding, licensing, franchising, and distribution issues. Michael, welcome to Franchise Today.
Paul, thanks very much. Pleasure to be here. Our thoughts go out to Warren, but I'll do my best to bring the zing from Plave Koch onto the show.
And I appreciate that. And I appreciate the short notice. It's really great of you and Plave Koch to be represented on today's show. It always seems that Plave Koch is right in the middle of some last-minute issues on Franchise Today. I think it was last year, a year and a half ago, Leslie Curran was supposed to be on the show, and it was supposed to be about brokers and broker relationships, and of course Leslie is well-versed on that. And the last minute, Leslie had to cancel. And I believe it was John from your office volunteered, and I know he was a little panicky at the last minute, and it was so he calls me 10 minutes before the show. He says, "Look, there's a bomb threat across the parking lot," and I'm on my cell phone, so I'm going to hang it. So I'm like, "Oh my God!" And then he went out to get to his car, but his car was cordoned off, so he had to get in his secretary, their admin's car, and he had to go to her house. He was running out of battery, but really no one knew the difference, and it was a fantastic show. So I expect the same. You've got a tall order, Michael, in front of you. Sure.
All right. Yeah. Go ahead.
Always a fun time at Plave Koch, right? Bomb threats.
Indeed. When you live in the Washington, D.C. area, you're unfortunately faced with those kinds of issues from time to time. But I do remember that day, and we'll just hope that it doesn't repeat itself.
I hope not. Well, today kicks off the 4th annual legal series, and we wanted to start off with franchise sales best practices, a legal perspective. And, of course, everybody's told me you're an expert on this. And,
I don't know who you're talking to.
So I think the first thing that we probably have to do in order to start this discussion is kind of look back as to why we even have franchise regulations. Why do we have them? What's the importance, and why is it necessary that franchisors really take this very seriously?
Sure. Well, we've had franchise regulations for probably close to 50 years now, originating in the state of California back in the 60s, and the federal government got into the game in the 70s by promulgating the FTC rule, which has been around since then. And you spoke about John, who stepped in for Leslie last year. John was actually the first administrator of the FTC rule when it was first written. And he was at the FTC for 10 years, and then he went into private practice. But so the states, beginning with California and others, have jumped into it, and the federal government also regulates franchises. And those laws and regulations popped up as a result of what both the states and the government believed were abuses that were going on in the industry on the part of franchisors. People, individuals who sought to purchase a franchise from certain companies were getting defrauded or losing money by virtue of whatever these people were saying or offering. And so the federal government realized that this is an arena that they need to jump into and regulate, and they've been regulating ever since, as do some states, but not all. But as a bottom line, the federal rule, the FTC rule, is what governs all of the United States, and to the extent a state also has chosen to regulate the offer and sale of franchises, those regulations are in addition to the federal requirements.
And then, of course, 2008, I believe, if my information is correct, some of these things we take for granted. The rule evolved into the current FDD, where we made the change from UFOC to FDD. And if you kind of give us some insight into some of the key changes and why they were necessary moving forward.
Sure. Without getting into too many specifics, what happened was the original rule was written, as I said, in the late 70s, and over time the states got together and created what was called a UFOC, a Uniform Franchise Offering Circular, and those were the things that the states that regulated franchises sort of all agreed upon would be acceptable in terms of a format to provide disclosure. And the FTC, over the time, even though the FTC rule was different from the format, slightly different from the format under the UFOC guidelines, the FTC permitted or at least deemed those other disclosures to be permissible. And that scheme went on for a long time, over almost 30 years, or maybe a long time in any event. Mm-hmm. And what the rule in 2007, when the FTC rule amended its rule, they basically adopted a lot of what the UFOC guidelines had been mandating over the last couple of decades, and so they had adopted those with some changes. And the rulemaking process, nothing goes quickly in the federal government, as you can imagine, and it took a long time. And obviously, there's some changes from the original UFOC, but the bottom line is they adopted many of those tweaks that the states and others had sort of been advocating for over the years. And so the FTC rule that we have now since 2007 sort of implements a lot of those things that people had been asking for or doing over time. And, one issue, which is very important, and I'm sure we're going to be talking about it a little bit today, is electronic disclosure, something that hadn't been contemplated, obviously, in 1979. Absolutely. So, the UFOC guidelines and that group had contemplated over the years, how are we going to address this? And the FTC rule amendment in 2007 gave the FTC the opportunity to sort of embrace these things that the states had been advocating over the years, and what practitioners had been doing, and it gave them the ability to sort of bring that together under the umbrella of the FTC rule.
You know, it's interesting you mentioned e-disclosure. Jonathan Redgrave of Redgrave LLP has been on the show a couple of times and talks about, you know, e-discovery and social media and the various things that can be brought into litigation, and obviously e-discovery, you know, is something that can be brought in, has to be made sure that it's documented correctly. Technology is brought into the equation to make sure that the delivery of the franchise disclosure document is proper, the receipt, etc. What is some of your advice with respect to franchisors when it comes to e-disclosure and some of the things that they need to do to make sure that they are doing this correctly?
Sure. And actually, you know, my advice is to follow what the FTC rule requires. And so the FTC has laid out what needs to be done, and you know, e-disclosure or electronic disclosure, you really have 4 basic steps to providing it to for a franchisor to provide electronic disclosure to a prospect. The first step is you have to inform them how they are going to deliver it. Electronic takes on, you know, multiple possibilities. When you think you could email it, you could make an FDD downloadable from a website. You could send a compact, a DVD ROM disk to somebody. So there are many formats that it can be received. So the first step is to tell them how it's going to be delivered. The second step is to, and by the way, when you do that, you're also obligated to let them know what the prospect might need in order to be able to view the FDD. So, for example, if you're going to send it as a PDF document, you would need to inform them that they would need to be able to read Adobe Acrobat and be able to view a PDF document. The second step, obviously, is to deliver it by whatever means you had told them you would do that. The third is to ask them, just at this stage, you're sort of at the same step you would have been had somebody sent out a hard copy of the FDD, but you ask the prospect to sign it, date it, and return it to you. Again, they could do that electronically if they wanted to, or you could get a hard copy returned. And then the fourth step is to keep a copy of the signed receipt. In the case of email, a lot of people try to send out read receipts and received receipts when you send out an email, and you know that is not going to cut it in terms of being able to prove that you've complied with the FTC rule. So it's important that when somebody gets the FDD document electronically, that they actually physically print it out and sign it, or if they can manipulate it on their computer, they could do it electronically. But the franchisor still needs those receipt, the hard copy or an emailed copy of the receipt back to prove that they've complied with the FTC rule.
So just to confirm, so an e-signature, very similar to what's utilized in some real estate transactions today, is acceptable with the electronic FDD?
Correct. It is.
Okay. And does that also extend to the franchise agreement?
It would. Okay. The E-Sign Act allows people to sign legal documents in that manner, and so an electronic signature is recognized in that respect.
Great. Thanks for clarifying. I know a lot of people, including myself, have always had questions with respect to that, and especially old-timers like myself. Well, I like seeing a physical signature on a piece of paper. But anyway, with respect to the FDD and the changes going back in 2007 and 2008, and I know there's been a lot of discussion about this within the various franchise limiting groups, a franchisor sends out the FDD electronically in one of the various formats that you mentioned. They're given instructions as to how to open it, have the proper software to read it, et cetera, et cetera. What is the law or guideline or recommendation with respect to somebody that says, that's fine, but I would like a physical copy? Is it a requirement of the franchisor to send a physical hard copy if they have been presenting it electronically? Does it extend to that?
Yes, it does. If somebody asks for a hard copy, they would have to provide it in that manner. That's exactly right.
Okay. That's interesting, because there was a lot of conflicting, quote-unquote, opinion on that. I believe that you did have to send it out to them in a hard copy, but a lot of people were disagreeing. So take that.
I mean, the bottom line is, showing what a franchisor is looking to do with providing disclosure is that, they've provided the franchisee, or the prospective franchisee, I should say, with, all of the information that they're obligated to provide. And if somebody says, I don't want it in this format, or if they throw up a barrier to their ability to be able to read it and say, I don't want to get it in this format, it's in the franchisor's best interest to provide a disclosure document in the manner that this prospect has requested, or just move on with a different prospect, only because you're going to create a problem that may never go away. They may always, if they end up becoming a franchisee, that's another little arrow in their quiver. And to the extent they have a problem with the franchisor, they'll say, yeah, and they never listened to me when I asked them to do it this way, and I didn't realize that. So, it's for franchisors, a lot of this is sort of making sure that they've provided their prospects with the information, in the manner that they've requested, simply because it helps to create that amicable relationship that a franchisor should hope to have with all of its franchisees.
Well, you're absolutely right, but all of that aside, Michael, I mean, it makes sense. I mean, why would you want to fight with them? Just a matter of printing it out, sending it to them for an overnight mail. It costs $20 or whatever the cost is, as opposed to arguing over it. I mean, isn't
Correct.
the objective to get it in their hand? I mean, so yeah, let common sense prevail even beyond the legal aspects of this. And you're exactly right. I mean, why put up a barrier to which should be a nice long 5, 10, or 20-year relationship? I mean, it's just ridiculous. Seems too many times people want to stand up on ceremony. Well, they could just go ahead and print it out themselves. Yeah,
right.
Anyway, so be it. So, with respect to the changes made in the disclosure document, there are certain areas that obviously have to be required practices, and of course some states, the registration states, have some slight differences. What specifically should, or better yet, which ones of these required practices are imperative that franchisors get right? Is there a list of 4 or 5 that you would say you absolutely have to get this right?
Well, maybe I'm not sure what you're asking in terms of. I mean, the franchisors have to get everything right. There really aren't aspects of the FTC rule that you can kind of fudge or work your way around. If it's required, it's required, and so maybe I'm not understanding what you're asking, but
well, I think that was a great answer to that question.
Okay.
Because I think that's the right answer. Too many times we know that there are franchise candidates that don't read the document, and it's in front of them. they become franchisees. And I say the same thing to franchisors. When was the last time you had a full understanding of what your requirement is under these laws and truly understood that? Then you wouldn't be asking the question, well, what are the key things that I need to get right? You're right. You need to get them all right.
That's exactly right. And it's not just, I'm not sure if you're talking about, because there are multiple aspects of, quote, getting it right, which include not just the preparation of the disclosure document, in other words, the content and what goes in it, but also how, number one, you comply with both the federal law and the state law. And in the states, there's no, for those who may not know, there's no obligation on the part of the federal law to file it with anybody. You just have to create a document that complies with that law. But then the states have a requirement that, or at least those registration states that do require this, require that you file that document with them and receive notice that document has been approved for registration in that state before you can then go, the franchisor can then go offer franchises in that state. So there's the compliance aspect to it, and then beyond that, once that has taken place, the franchisor then needs to be sure, and I think that's very relevant to what we're talking about today, the franchisor needs to be sure that not just the vice president of sales, not just the CEO, but every individual in their organization who is involved in the sales process, that every individual is aware of what the rules and requirements are, and that they are complying with it. And there is no, this guy doesn't have to pay attention, but these people do. So there are really many phases in franchisor compliance with all of these rules, and it really never ends until, from a pre-sale disclosure standpoint, it never ends until that franchise agreement is signed. Once that happens, all of the things we're talking about today are behind the franchisor, and there are obviously other requirements that step in at that point, like relationship laws. But once the franchise agreement is signed, everything we're talking about today basically goes away.
I think you either you might chuckle, cringe, or just say, "I'm not surprised" when I tell you this. Recently, I was talking with several franchisors, and of course, at Franchise Foundry, I'm the CEO and president. We're a full management and development company, and we're talking with some franchisors about doing some work for them. And there was a handful in particular that basically said, no, we get it all right. And I'm confident with everybody they have. And there was three in particular. Each of them had three franchise salespeople, including, VP, director of franchise development, different titles. And I said, would you humor me by having them take a multiple choice test that I'll put together specific to your FDD? And he said, absolutely. So we put together a 20-question test for each of the three brands, and they were multiple choice questions, and they weren't about the legal language, the legal aspects of the FDD. It was stuff like, how much is your franchise fee? There was questions about, applicable discounts for multiple units. There was questions about the range of the initial investment. And there was 20 questions that were very, very general, but yet were key components of their respective FDDs. The long and the short of it is, based on a passing score of 70, 8 of 9 that took the test, that was 3 from 3 different organizations, failed the test. Across the board, they see you chuckling. Across the board, they all got the franchise fee right, okay? A handful got wrong the discount that applied if they bought multiple units. hardly any of them got right the range as specified in the FDD of the initial investment. And it went on and on and on. And really, the franchisors the CEOs I spoke with about it, and we went over it, were just aghast. And quite frankly, I was too. What are your thoughts, now that I heard the chuckle, what are your thoughts to that type of situation?
Well, my first thought is it doesn't surprise me. There are very few organizations out there that have the kind of programs in place and implemented to be able to give those quizzes, for example, or to make sure that every individual in the sales process has perfect knowledge of what is in the FDD. And by the way, that's the requirement under the FTC rule, is that when sales personnel are talking with prospective franchisees, they can't say anything that's inconsistent with what is in the FDD. And so, the most important aspect of creating a compliance program for a franchise or organization would be to make sure that the people who are involved in the sales process understand the program, as you demonstrated is rare, or at least in that circumstance wasn't at least very consistently done. And also to be sure, not just the content, but also how they can speak with prospects and the kinds of things they can say. I assume we're going to be talking at some point about what used to be called earnings claims. They're now financial performance representations. But that's a perfect example of what sales personnel need to know what they can and can't say. It brings up an interesting circumstance that I can recall from one of our clients. We do their regulatory work, and we help them prepare an FDD every year. And so they get the FDD, and we don't know what they do with it. They file it away, and we explain to them how to do it, and we go through sales compliance seminars explaining to all of the individuals how they should be doing this. But an important aspect of that is to understand that every person who is involved in the process needs to be aware of how this works. It's one thing to provide a sales discussion with the CEO and the vice president of sales and maybe some sales individuals, but even administrative staff who might have their fingers in the process really need to know about these things. The client we had been sending FDDs to had been filing them away, and we visited their offices one day, and there was an administrative personnel there, and she opens up a drawer and she says, "Here's where we keep our FDDs." And we had maybe just sent them the 2011 FDD, and we asked where the most recent one was, and she said, "Well, I like these ones better," and they were earlier versions of the FDD, the 2008 or 2009. We like these versions better, or I like to send these out better. And so everything that we had done with other individuals and spoken to, sort of explained how the process works in letters, seminars, and the like, is all out the door once that one individual has the ability to sort of thwart everything we'd been doing. And so it's a perfect example of how everybody in the organization needs to be aware, so that the sales compliance is only as strong as the weakest link, as that circumstance demonstrates.
Absolutely. We're live on Franchise Today. Today's kicking off our 4th annual Franchise Legal Series, and my guest today is Michael Laidhold from Plave Koch. As you were talking, I'm looking at the time. We're already halfway through the show, and I'm thinking along the lines of Chief Brody in Jaws when he said, "We need a bigger boat." We certainly need a lot more time. But you're right. We do need to talk about FPRs. But before we do, item 19, before we do, as you were talking about the organization and, people saying, I like these better and what have you, and in light of what I said about various franchise sales professionals that couldn't even pass a basic test on their own brand's FDD, I think this lends to something that I know Warren has spoken quite a bit about in the past, which is a culture of compliance and actually just a good, solid culture within the organization of fully understanding what needs to be done at every point in the process in dealing with candidates and in dealing with franchisees. Do you have any thoughts with respect to a culture of compliance?
Absolutely. And the culture of compliance, I don't want to toot the horn of my industry, but it really begins with legal counsel, whether that's an in-house attorney or an outside counsel that is involved in the organization. It's important for the organization sort of embrace what that counsel's guidance in the sales process. And when it comes to culture, there are really two competing in franchise sales. There are two very much competing interests when it comes to providing disclosure. The first would be obviously the sales aspect, which is a franchisor's goal is to sell more franchises. And in order to do that, certain things need to be said, and certain information needs to be provided to prospective franchisees. And sometimes the sales interests can be, let's just get the deal done, and it can be fast and loose. The competing interest, the yin to that yang, so to speak, would be the legal compliance side. And a lot of that can be viewed as sort of putting a brakes on the sales process, but really it's making sure that all of the I's are dotted and the T's are crossed when it comes to complying with both the federal and state requirements. And so it's important as a culture for organizations to sort of take both sides of those competing interests and combine them into one in the best manner possible. It's not no one's going to be perfect, but they can try their best to sort of meld both the legal compliance interests with the sales interests, and they're going to give and take. But the best culture that an organization can have would be one that addresses both adequately.
Yeah, and definitely heed Michael's advice, but make sure you're not dotting your T's and crossing your I's. That certainly isn't the right way.
Is that what I said?
Anyway, no, you didn't. I'll just,
Okay.
Sometimes people hear what they want to hear, right?
Right, exactly.
FPRs, financial performance representations, are, as we lovingly know, the infamous Item 19. And I know Lane Fisher has spoken on Franchise Today in our past legal series about the FPR, friend or foe, and how it should be utilized. So what is your opinion, or what would your response be to a franchisor that says to you, do I really need an FPR?
That's an excellent question. The answer would be...
I told you we needed a bigger boat.
The answer is, a financial performance representation is the one disclosure under all of these regulations and laws that we're talking about that's done on a voluntary basis. So as you noted, a franchisor has the ability to choose to provide an FPR or to not provide an FPR. It's my and I think the answer to the question is personal. But personally, I believe that if a franchisor can provide an FPR and can tell a story about what however they want to, and by the way, there's a lot of latitude as to how an FPR is both created and disclosed. As long as it tells a good story and obviously is accurate, that can be a very valuable tool. The the opposite of that, the consequence of not providing an FPR in your FDD is that you have to disclose in your document that you do not and cannot say anything about what a franchisee can earn, because invariably every prospect comes and says to the franchisor, well, how much am I going to make? And if you do not provide an FPR, then the franchisor is going to have to say, we can't tell you. Obviously, they can point them to other franchisees to be able to speak with them and ask them what they make. So in answer to your question, I think if a franchisor can provide that information, it's reliable, it tells a good story, and maybe if it tells a bad story, it's also an important piece from the legal compliance standpoint, is everybody really ought to know how everybody's doing. But in any event, if you can provide it, it can be a very useful tool in the sales process, but it has to be done right, or else there's a lot of liability that goes along with financial performance representations, simply because that's what everybody hones in on and is focused on.
Sure, and I think an extension of that too is making sure that the franchise salespeople understand their own Item 19 and understand how to explain it, because it has to be explained as it is written and inserted and included in the FDD. And I think that transition is where franchisors could get caught between a rock and a hard place.
Yes, that's right. And so for the sales individuals who are, let's take a franchisor who has chosen to provide an FPR in their disclosure document, it's not enough for the sales personnel to simply know that they've provided the FPR. They obviously have to know what it says, because if for example the disclosure is average unit sales, the sales personnel should not be talking about other aspects of the number of burgers sold, or whatever it is, other information that isn't in the FPR. So that's exactly right. They need to, the things that are discussed need to mirror the information that is disclosed in the FDD. Exactly.
Yeah, and one bit of advice to the franchise salespeople out there is, don't look at that and tell the franchisee, well, you've got information here, you do the math. It's not acceptable. As we talk about different people in the sales process, and you talked before about franchise sellers and people involved, as it relates to the FDD, and I know various states are a little bit more picky-uni about it, so to speak. Define for our audience, who is a franchise seller and who must be included in the FDD?
Well, so a franchise seller is anybody that is involved in company X's sales process. It usually involves employees of the company itself, but is not limited to those employees. And so what some franchisors do is to basically enter into a relationship with other companies, such as Franchise Foundry, and to engage them to provide sales assistance in their programs. And what those people, you can call them sellers, but they're also would be referred to as brokers, in the sense that they're not employees of the franchisor. They are third parties, but they're also involved in the sales process. Now, brokers used to have to be, information regarding brokers used to have to be disclosed in the FDD. That's no longer the case. So as to who goes in the FDD specifically, it's limited to the employees of the franchisor. And by the way, in terms of actual franchise sellers, those individuals do not necessarily need to be part of the FDD. Item 2 is where we talk about the officers and directors of the franchisor who are disclosed to prospects. Sellers, the individuals who work for the company who might be involved in the sales process, do not need to be in the disclosure document necessarily, unless they are an individual with the organization that would have what's called management responsibility with respect to the franchise program. So sellers themselves do not necessarily need to go in. They might also have those additional responsibilities that would necessitate going in. But if they're not in the FDD, then there is the federal requirement is satisfied. There's no additional information from the FTC rule that needs to be disclosed about sellers. The next step is for those states that regulate franchising, the franchise registration states. Some of them have requirements that you provide what are called seller disclosure forms to them. So when a franchisor applies to register in that state, they also provide additional information about who the sellers are. And those are specific forms that they need to submit. And they would provide those for any individuals, be it broker or employees of the company that are involved in the sales process.
I understand that there are some special disclosure situations, and I think there's a little confusion, and sometimes I'm even confused about when it is not necessary, and I'll repeat that, when it is not necessary to provide a FDD for a more financially astute group. Can you kind of give me an explanation of what those circumstances would be where an FDD is not required?
Sure. So as part of, there have always been certain exemptions to the FTC rule, both on the federal side and on the state side. In 2000, in the recent amendments to the FTC rule, the FDD guidelines, allow franchisors to. They basically expanded the exemptions to the rule. So there are additional circumstances that the federal government recognizes as being circumstances where an FDD does not need to be provided to a certain prospect. There are many different areas where this can apply, but one of those exemptions is for a large franchisee, and as you mentioned, well-heeled. There are certain minimum net worth threshold requirements. If a group or an individual meets those requirements, then it's more than X million. Then that particular transaction would be exempt from the FTC rule, the requirement to provide disclosure. States similarly have exemptions to at least their registration requirements. So, for certain large franchisors who might be worth more than X dollars are able to avoid the need to register their document with the state, but they would still need to comply with the FTC rule and provide disclosure. So, really, to avoid providing a disclosure document to a franchisee, you need to be able to comply with those specific exemptions to the FTC rule. There are others. For example, if you're a developer and you're developing additional units that you originally disclosed, and you're developing additional units under the same guise of the original disclosure, then as long as there's no substantial change, then again that might be exempt as well, depending on the circumstances. But that's sort of where counsel comes in order to let somebody know whether or not a particular transaction is exempt. But those are much more available now after following 2007 than they were in the past under the FTC rule.
There's another question that I see come up quite a bit within the discussion groups pertains to redisclosure, and of course in the case of a quote-unquote material change. And of course I'm always of the mindset, redisclose if there's any doubt whatsoever. But what's a quick rule of thumb from you with respect to the need for redisclosure?
When you say redisclosure, I'm assuming you're talking about before the franchise agreement is sold, correct?
That's correct.
Right. Well, I mean that you basically summed it up in your question, which is if there is, so if a franchisor provides a disclosure document, let's say for example in June of this year, and maybe it's a non-registration state, and then they're talking with the prospect. It takes several months to conclude the transaction. They're planning on signing the franchise agreement later in the year, maybe it's October. And in the interim, the franchisor has had certain events that have occurred. Either maybe the CEO left, or maybe there's been some significant litigation, or maybe a lot of franchisees have been terminated. Whatever would be deemed material, and in your bigger boat analogy, that's a show for another day in terms of what is and isn't a material change. But assuming an event to be material, the franchisor is obligated to update its FDD to reflect that material information. And to the extent the franchise agreement has not been signed yet, the franchisor is also obligated to provide that material, the revised FDD with the new material information, to the prospect before they sign the franchise agreement. And
then if they are redisclosed, the appropriate waiting time applies.
Correct.
All over again.
Exactly.
It's interesting you mentioned about a material change being or a CEO leaving being a material change, because I think a lot of people within franchising look at material changes as a significant change in a financial position, a legal matter, judgment, lawsuit, etc. And a lot of times don't look at it from the perspective as a key manager, key part of the executive team leaving. So I'm glad you clarified as such. One more question with respect to disclosures. It always seems to be a gray area, at least in my mind. And I'll give you a hypothetical here. You take a registration state, and there's a franchisee in the registration state, and he is looking to sell his business. Yet, at this point, the franchisor is not registered in that state. He was and abided by all the laws, etc., when they signed on the franchisee. But now subsequently, let's say they decided not to continue franchising in that state, but have an existing franchisee now that is looking to sell. And they're not registered in that state anymore. How does a resale of that franchise take place, and how is disclosure achieved with a new franchisee coming in at that point?
Well, most of the registration states have addressed that circumstance in the form of an exemption from their registration and disclosure requirements. And usually the exemption reads something to the effect of the franchisor need not be registered in the state or provide disclosure to a prospective franchisee if it's a franchisee selling its own franchise business on its own account. So in your circumstance where a franchisee wants to transfer its business to somebody else, again, on its own account, not, mind you, the franchisor going out and finding somebody for the franchisee, hey, sell it to this guy. If the franchisee says, hey, I want to sell my business to somebody, that transaction is exempt from the registration state requirements. Similarly, under the FTC rule, that's an exemption as well. The rationale behind that is, the franchise business is a commodity that ought to be able to be bought and sold, irregardless of whether the franchisor has discontinued its program to continue to offer and sell franchises. So franchisees need to be able to continue to sell their business to somebody else despite the franchisor's plans. The franchisor can, the exemptions usually say something to the effect of just because the franchisor has approved the prospective franchisee does not mean that they had a hand in selecting them or the transfer process. So, that kind of a transfer scenario is permissible under that rationale and because of those exemptions.
So just to clarify one point, the franchisor cannot direct quote-unquote leads to the franchisee for the sake of a resale. In other words, if the franchisee, it was Virginia, let's say, had 40 leads in Virginia, but they have an offer to franchise to because they're not registered, they can't direct those leads to the franchisee for the resale. The lead has to come from a franchisee or a local business broker. Is that correct?
That's correct. And
okay.
Again, the rationale makes sense.
Sure.
If it wasn't that way, then franchisors could thwart their obligation to provide disclosure by, just saying, well, we can get around this by telling, franchisees to sell to others, and they can kind of keep it going. So that's correct.
Yeah, the whole get around the situation can definitely be another show for another day with respect to franchising and licensing and all those things. But anyway, as we're closing in on the top of the hour, and I told you, Michael, this would fly by, the key component of this show that I think is necessary to talk about is getting your perspective on, not even your perspective, give us some facts. What are potential penalties and consequences a franchisor can be exposed to if they do not comply to these laws?
There are many possibilities. The first of which would be actions by both the federal administrative actions on the part of the regulating bodies. So that would be the FTC or the state that's involved. So if we're talking about Maryland, for example, if the franchisor has not complied with, for example, the FTC rule, the FTC itself could choose, if they were made aware of the situation, they could choose to go after the franchisor. And they can assess civil penalties as well as, in certain willful scenarios, criminal penalties in extreme cases. The states also reserve to themselves, the franchise registration states reserve to themselves the right, again, to bring administrative actions against franchisors for not complying with the law. Then additional, moving on from administrative action would be actions on the part of a franchisee, what we would call private actions. And those can result in the franchisor paying damages. It can lead to rescission, rescission being the franchisor's obligation to offer the franchisee to basically get out of the business. Here's your money back. We'll cancel the contract and we can go our separate ways. Sometimes just an offer of rescission takes care of that scenario. Franchisors can be liable to franchisees for legal fees, civil fines, punitive damages. They can be up to treble damages. And there's another aspect of non-compliance that some franchisors don't realize, but if any of this happens and something goes wrong, that action is something that the franchisor is going to have to disclose in their FDD for 10 years down the road. The fact that they didn't comply with whatever law, or if it's a private lawsuit with a franchisee, then that will be disclosed in their FDD for 10 years on a going forward basis.
Well, certainly we needed a bigger boat today. There's so many unanswered questions, and hopefully through the legal series we'll be addressing a lot of them. Michael, great show today. A lot of great information you provided. I really appreciate you being part of our 4th annual legal series here on Franchise Today.
It's been my pleasure. Thanks for having me.
Now, next week, the series continues, Thursday, April 18th, 11 a.m. Central Time, 12 p.m. Eastern Time, with Lee Plave, also of Plave Koch. Should be an exciting show. Until then, my name is Paul Segreto, wishing you the best, the very best, in this great, great, great thing we call franchising. Franchise today is out.
When it's PCS time, you know the drill. Pack, research the new base, get the kids in school, because family supports family. At American Public University, we support military families with flexible, affordable online education that moves with you. As a military spouse, your tuition rate is the same as your partner's, just $250 per credit hour. American Public University, education that moves with you. Learn more at apu.apus.edu/military.